Hi, I'm Emily and I am here with Maya Murphy's attorney, H. Daniel Murphy. Attorney Murphy practices at Maya Murphy's law offices in both New York and Connecticut. My question today for Attorney Murphy is, in a divorce, what about college expenses? How are those typically dealt with by the court or by the parties?
So in Connecticut, the child support guidelines provide for child support and support of a minor child until the child turns 18 or graduates from high school, but not past 19. But there is also the question that's an important one for a child of around that age, and that is allocating responsibility for college expenses, or as we call it, post-secondary educational expenses in the law. And these are called educational support orders. In general, the court, for court to decide how the parties are going to be allocated responsibility for educational support, the court has to first find, or the parties have to agree that they would have, if they had remained an intact family, that the child would have attended college and that the parents would have provided for those expenses for college. So the court has to make a finding of that, as well as determining that the parents have sufficient income or assets to provide in some fashion for college expenses, and take into consideration other financial responsibilities of the parents, as well as any plans for the child himself or herself to contribute to those expenses, whether that's by income, by some sort of savings plan, a 529 plan, a trust, a custodial account of some kind that might already be in existence, or by student loans. So in Connecticut, the law is that a court may only allocate responsibility for post-secondary educational expenses for costs, that's tuition, room and board, and fees, up to the cost of a child to attend the University of Connecticut as a full-time resident on campus. So that's called the Yukon Cap. In other words, a court can't obligate either party or both parties to pay for the cost of an Ivy League education, regardless of how expensive it is, but rather there's a ceiling. And the ceiling typically, or the ceiling according to law, is the Yukon Cap. And that obviously fluctuates as the cost for an in-state student at Yukon has risen over the years. But that is the cap. Now, that can only run through a child's 23rd birthday. This obligation for educational support orders. And as far as the Yukon Cap, the parties in a divorce can waive that cap. They can contract to be responsible for costs above that amount, but it would have to be by agreement. In other words, if one of the parties doesn't agree to that, then the court only has jurisdiction to award up to 100% of the costs of the Yukon Cap. So another thing that happens in situations where the children are very young at the time of the divorce, or maybe in situations where the parents' income or financial circumstances are especially volatile, the court has the option, and the parties have the option, to ask the court to reserve jurisdiction to address this issue. So what does that mean? That's essentially delaying the decision at this point in time, or to use the expression, kicking the can down the road. And that means that the parties are asking the court and giving the court authority to deal with that issue at another time, only if and when the parties can't reach an agreement on their own. So at that time, the children are coming close to college age, and if the parties are unable to work it out, whether by themselves or with attorneys, either party can petition the court for a hearing, essentially to intervene and to listen to all the evidence and decide what would be fair and equitable in applying its jurisdiction to find how college expenses and educational support orders should be divided between the parents. And even if the divorce was many years earlier, the court is only addressing the current circumstances. So this, sometimes you have a divorce that was maybe 10, 15 years earlier. The parties are now in front of the judge. Yes, there may be an issue where the parties might disagree as to whether they would have jointly provided or endeavored to provide for college education expenses for the child. But beyond that, the court is really going to be looking at that time at the current financial circumstances, what the parties are currently earning, what they have, and how those expenses should be allocated at that point in time, since the parties don't agree. So if you have any questions about educational support orders, either during a divorce as you're going through the process, or many years afterwards, if there's no agreement on the subject, you should certainly speak with an experienced family law attorney about your options in this regard. Thank you.